Welcome to another episode of Conduct Detrimental. Dan Wallach, Dan Lust, Team Conduct Detrimental is back. A loaded show for today. We are going to finish off, with the Deshaun Watson saga with some final thoughts. And then one of our old kind of like potpourri episodes, we're going to go around the horn of sports. Tony Buzbee just couldn't get enough of the NFL world. He is back representing a victim of Saints running back, or alleged victim of Alvin Kamara. Nick Kyrgios, former Wimbledon finalist in tennis, has an interesting defamation case. Dan is going to break down the latest in the Florida sports betting legal saga. The Vanessa Bryant case is reaching a conclusion. That's the crash site photos case. And last but not least, Dennis Rodman pops up offering his helping hand with the Brittney Griner situation in Russia. But Dan, I think it's only appropriate that we start with Deshaun Watson.
Man, I thought I was going to be in federal court this week. I had a completely different week all lined up than the week we actually have now. We were going to have the battle of the forums. Who's going to file suit first? Delaware, New York, Ohio. We were going to have motion practice. This was all going to be compressed into such a short period of time. This was sort of the sequel to Deflategate and Ezekiel Elliott. And just when you thought it was going to happen, they reached a settlement. They reached a settlement right before the arbitrator was poised to issue a ruling, and that would have obviously led to federal court at some point. So in some ways, I'm disappointed, but I'm really not surprised given the vulnerabilities that each side had. I mean, after all, this arbitrator, Peter Harvey, he was going to issue a 17-game suspension plus postseason, and the likelihood of that being upheld in federal court is probably very high. So it made sense for Watson to take 11 games and for the league to eliminate the risk of losing in federal court.
Yes, I don't think either of us were necessarily surprised. If people listened to the last episode, Dan, we gave you your flowers as many times as we could. You nailed the prediction, 11 games. There were other people, and they will remain nameless on this podcast. They said they predicted 11 games. And I'm like, where are the receipts? And they're like, oh, I don't have the receipts. So, Dan, as far as I know, you were the only person that predicted 11 games. So bravo, my friend.
The brilliance of that was I should have bought lottery tickets that day, because the day before I was on Cleveland television, radio, predicting 10 games. And on Twitter, 10 games was a sweet spot because it would be tied for the longest suspension in the history of the personal conduct policy. And then about an hour before the settlement was announced, I started having misgivings over that prediction. I go, well, tied isn't going to give the NFL its pound of flesh. They want to break the record, and 11 would break the record. And it's such an oddball number that I could see the league wanting 12, Watson wanting 10, 11 breaks the record. And then an hour before the announcement, I switched my prediction. Unfortunately, you can't put money on those kinds of things, and you can't put money on sports law or sports betting law predictions. Otherwise, I would have been a multi-billionaire many times over by now. But I'll enjoy that one. But certainly, it's a settlement that makes sense for both sides. What do you think about that, Dan? Do you see this as a fair, just, and consistent settlement? Is this satisfactory from all sides of looking at this?
I started teaching my sports law class at New York Law School this past week. And the first class, I just covered Deshaun Watson. And the second class is going to be explaining what the comments that Watson might have made if he took this case to federal court. We're not going to spend the whole episode talking about Watson. Don't worry, we've been covering Watson a lot. But there is one point, Dan, that I think you and I disagree on, which I think the listeners may be interested to hear the back and forth on. I think everyone leaves with failing grades from a PR perspective. I think the Watson camp looks bad. I think the Browns look bad. I think the NFL look bad. I understand from a legal perspective, like how the NFL can paint this as a win, right? The longest suspension ever, the $7 million that go to charity. Watson has to meet with a behavioral expert. The NFL, Watson put his foot down at 8 games originally, and then they got him to 11. Like, I get that side of it, and I get Watson's standpoint, right? He's not getting suspended for a full year. That suspension gets to be completely within that 1 year, which he happens to be making $1 million. So he doesn't risk his suspension going into that second year and third year salaries where he's making $45 million a year. So I get how each side is painting it as a win. But Dan, you asked me what I think about the settlement. In my core, I still do find it to be a light settlement. I think if you look at it, the big picture, great. He's suspended for more than half a season. That's very big, $7 million, a lot of money. But I can't escape the math. I can't do it, right? Judge Robinson here found that the NFL won their case, established beyond a preponderance of the evidence that 4 sexual assaults occurred. And we don't know the time frame, but we know that the 24 allegations were from March of 2020, I think right around there, to the beginning of 2021. So, you could say this is a pattern. You could say that things are similar. But to me, those are 4 separate violations of the personal conduct policy. So to me, I'm doing basic math. I said it on the last episode. You weren't here to defend the point, so you're here now. 11 games suspension divided by 4 counts of sexual assault. To me, 2.75 games per sexual assault, which I can't escape the fact that that seems light. So that's me.
First of all, I think that's an impractical way of proceeding for 2 reasons. What if all 25 plaintiffs, and I've raised this, I think, on our Twitter spaces, but 25 plaintiffs come forward, let's say the NFL finds all 25 credible, you're going to suspend Deshaun Watson for 5 years? At what point do you just eliminate?
Don't do the time, don't do the crime, right? That's what the expression is.
It's not calculus, but there's also the issue of prior precedent. Judge Robinson pointed to a number of other cases mainly involving violent sexual assault, where the top line suspensions were 8 games twice and 10 games once. And each of those 3 cases involved multiple victims, multiple incidents. And in one case, a guilty plea to a criminal battery, yet despite there being a minimum 6-game suspension for personal conduct policy violation for crimes of violence, there was no escalator on a per offense basis. So if the NFL wasn't doing the math, so to speak, and multiplying it per offense in those 3 prior incidents that she had pointed to as governing prior arbitral precedent, well, she's not going to be able to do it here, lest that type of suspension, 2.5 games times the number of incidents, could be considered arbitrary discipline if he's getting consecutively punished when the prior violators who committed violent sexual conduct violations didn't get charged or suspended on a per offense basis, that they were grouped together and maybe there was an escalator, but not sort of the math, because in Watson's case, that would be totally impracticable to have all 25 plaintiffs potentially, which would have been plausible here, all 25 plaintiffs cooperating, their cases are credible, and then we don't see Deshaun Watson until 2028 when I'm collecting Social Security. So that's not viable for me. But I want to finish on one really important point on why I think this is a really fair settlement. I don't consider it light at all. Deshaun Watson is missing 11 games this year, 17 games last year, and Judge Robinson pointed to those missed games as a mitigating factor because in some part it was attributable to the uncertainty surrounding his criminal/civil situation. So to some degree, Watson paid a price for it in the 2021 regular season. So I think given the likelihood that Arbitrator Harvey would have suspended for at least 17 games, and then the chalk in federal court, the high likelihood in federal court is that labor arbitration awards are upheld close to 90% of the time, even more so in the Southern District of New York. So when the dust settles, he'd be looking at having judicial confirmation of a 17-game suspension and potentially winning in the district court and then ultimately losing that battle on appeal before either the Third Circuit, Sixth Circuit, or Second Circuit, and then facing 3 consecutive years of having to do the time, missing all of last year, missing 6 games this year, and then having the additional 11 games tacked on in 2023 if and when he loses a federal court appeal. So I think he did the smart thing here. I believe the league also gets its important baseline of 11 games. So the next time a player is charged with a non-violent act of sexual misconduct, the league might be able to point to prior arbitral precedent of a settlement leading to 11 games. Now, I haven't read the terms of the settlement agreement. I don't know if 11 games can actually serve as arbitral precedent because it was done via a settlement agreement rather than a disciplinary quote unquote ruling. But I think the league gets what it wants in terms of going forward, having other players potentially being subjected to up through and including 11 games for conduct similar to Deshaun Watson's. My final point is monetary. I'm cynical. I think Deshaun Watson may have traded games for money because by settling now, by agreeing to a higher suspension over and above 8 games, he agreed to an additional 3 games. He kept a lot more of his money than if he had left the sentencing to Arbitrator Harvey's discretion. And the arbitrator could have normalized the monetary fine and not just simply pegged it to this year's compensation. He could have imposed a fine equivalent to what the average of 11 games would have been over the course of a 5-year contract. So I'm cynical. I believe that Watson took the extra games in order to reduce the monetary hit and keep it to this year's money and not have it potentially be a $10 million or more fine. So I think it's a great settlement for Watson, and it's a smart, prudent settlement for the league, given the unprecedented nature of the suspension here. 11 games, no incident in the history of the National Football League's personal conduct policy ever reach the height of an 11-game suspension, and there've certainly been worse incidents than this.
Okay, so it is what it is. We'll watch the case moving forward.
Is there going to be a case moving forward? I hope so.
There is one civil case remaining. The statute of limitations, as far as I know, has not run on some other ones, but we will see. We will see, Dan. Okay, for our next topic, we are going to talk about maybe the common nucleus between these two, at least the most obvious one. Tony Buzbee represented all 24 civil lawsuits filed in the Deshaun Watson case. He has now turned around and he is representing Alvin Kamara's alleged accuser. So this is a quote from the Tony Buzbee law firm. Quote, Darnell Green, the victim viciously assaulted while attempting to enter an elevator at the Cromwell Hotel and Casino in Las Vegas in February 2022 by New Orleans Saints running back Alvin Kamara. Kansas City Chiefs defensive back Chris Lamons and others has retained Tony Buzbee and the Buzbee Law Firm of Houston, Texas to assist in the investigation and pursue legal claims. So a little bit of a background, then once in a while I have a funny story. So people were trying to figure out what was going on February 22. It was the Pro Bowl. Pro Bowl used to occur over in Hawaii after the Super Bowl, and no one paid attention to it this year. In most recent years, they've played it the week before the Super Bowl. So that's why Alvin Kamara was in Vegas with some other members of the NFL. It's an interesting case. I think we've covered it on the podcast. I know I've covered it on other shows. There is a surveillance camera footage that shows an individual, apparently by the name of Darnell Green, getting into an altercation with Alvin Kamara and his crew. And the video camera appears to show Alvin Kamara striking this individual. So, okay, camera is one thing, right? Picture says 1,000 words. I say video says 1,000,000. Then if it wasn't just that, Alvin Kamara then went to the precinct afterwards and gave a statement without an attorney present. So picture says 1,000 words, video says 1,000,000. I don't know, you saying in your own words maybe probably says all that you need to know. I would think a strong case from a number of evidentiary levels, but that's where we're at. I have heard nothing from the NFL with respect to an Alvin Kamara suspension, but looks like this criminal case, civil case, looks like they're heating up, Dan. So what say you on this front?
Yeah, I mean, these are really serious injuries. I mean, I've taken a look at some of the media surrounding, the original reporting. I mean, severe traumatic brain injury, spinal injuries in his neck and his back. I mean, this could be a major lawsuit. And I would expect Tony Buzbee to employ his typical playbook, which is this is not going to be good news for Alvin Kamara. This is not going to be good news for the New Orleans Saints or even the National Football League, because he's going to keep constant pressure on. And he's already employed chapter 1 of his playbook, which is to ask Las Vegas prosecutors to charge Kamara with a crime. I mean, he's done that I don't know whatever became of the criminal investigation, but Buzbee's, sort of three-pronged attack is use the civil court system, the criminal system, and then push the NFL by having constant press conferences. And this matter was really not heavily reported on in the last couple of weeks. It seemed to really be lost in the shuffle with all of the other recent news. Well, Tony Buzbee is going to keep a bright spotlight on this matter. And I think this is probably going to point to the NFL accelerating its decision, surrounding discipline for Alvin Kamara. I mean, this is a true crime of violence, and we're looking at a minimum 6-game suspension unless somebody else caused those injuries. So this is not good news for anybody because Buzbee will not go away. He will he'll work the press and keep constant pressure on the responsible parties here. So I think this could be good for the plaintiff. And it's also pushes the likelihood that there'll be some disciplinary decision at some point very soon. I can't see how Kamara avoids anything less than a 6-game suspension when you look at these injuries.
I'm with you. I'm not sure. It's the injuries is one thing, but let's not forget, right? It's the video evidence, which we did not have in the Deshaun Watson saga. It's the admissions to police, which we did not have in the Deshaun Watson saga. So, yeah, I mean, Kamara was arrested and charged with battery resulting in substantial bodily harm. So he was arrested. I've been following the court appearances. I don't think much is happening at this point. I don't think he was present for the last court appearance. Obviously, training camp has started, and I've spoke to people with the New Orleans media. They're on pins and needles. I told them my prediction that I thought Kamara gets suspended, but as the season gets closer and closer, right? Your friend Mike Florio reported that the NFL has no timetable on a suspension. So I've been wrong before. It looks like I'm going to be wrong here. Kamara might actually be playing in week 1, as crazy as that sounds.
Well, why isn't he on the commissioner's exempt list? Remember, there was this debate about whether Deshaun Watson is going to, sort of influence the NFL's actions here potentially, because the league withheld any decision on whether to place Watson on the exempt list. They waited until after the 2021 season. But the touchstone for whether a player goes on the commissioner's exempt list is whether the underlying offense involves a crime or an alleged crime of violence. And I think Kamara's alleged conduct meets the criteria for being on the commissioner's exempt list. And if he's charged, or I guess he has been charged, he's had court appearances. This to me is the obvious situation for using the commissioner's exempt list. And the fact that Kamara isn't on the exempt list to me is stunning. And my ultimate question isn't, or the issue for me isn't whether he's going to be suspended for 6 games. 6 games is a starting point, Dan, under the personal conduct policy. That's a minimum baseline suspension, and there could be aggravating factors, including the severity of the injuries. And this seems like it could be a violation that could merit or warrant a full year suspension. I mean, if Watson got 11 games, I guess consensually through a settlement for nonviolent sexual conduct, well, then how are you going to discipline a player who commits a more severe act of violence where the victim may not be the same ever again? Is 6 games going to be enough relative to Watson's 11? Can you compare the two? Are they in the same box, so to speak, for comparison purposes?
Yeah, this is going to be a running theme through our episodes. I mean, the NFL happens to just, there's a lot of content here, but the NFL is walking themselves into a lot of trouble with these inconsistent, I don't want to say games, handling, whatever. And I understand that Calvin Ridley was suspended under a different policy than the one applicable to Deshaun Watson, and so on and so forth. We can dispel all of that, but the optics will remain, right? Stephen Ross, the owner of the Miami Dolphins, which you and I spoke about, Dan, like 6 games for tampering with Brady. Meanwhile, DeAndre Hopkins, the wide receiver for the Arizona Cardinals, he gets 6 games. Deshaun Watson originally got 6 games. These are all over the place. So I call it like I see it. This was an arrest for a felony battery charge. Deshaun Watson was never charged with a crime. And we don't always have to talk about football. Trevor Bauer, right, was never charged with a crime. So here is someone that was charged with a crime.
A felony, no less.
Right. Maybe we'll look back in this a month or two and say the NFL was waiting for some reason. But as of today, right, as we record this on, in late August, it just seems odd. And I did promise I had a funny story for you. We have to at least talk about our friend Tony Buzbee here. Tony Buzbee is not, we'll say, the most popular figure in Houston. That's where these Harris County cases were filed. I was telling the story in my class on Monday, like the one thing that Deshaun Watson people kept saying, right? The Deshaun Watson, people in my replies, like, all of these women are represented by the same attorney. Isn't that suspicious? And I'm like, well, it's not necessarily that suspicious. Maybe they just want to use the same firm and they want to be on a united front. It's not that crazy. But to me, I found it odder that the person that they picked to be that one unifying attorney was Tony Buzbee. I found that to be odd because Tony Buzbee is known for doing all sorts of things, running for public office, making different cases about himself. It just didn't seem like a case where the optics made sense for a variety of reasons. But Tony Buzbee, hate him, love him, the guy, what's the expression, Dan? Hate it or love it, the underdog's on top. Tony Buzbee's not an underdog, but hate it or love it, he keeps popping up in these stories. So we gotta keep dealing.
Here's why you got all 25 cases, because you got the first one. Once you get the first one, I mean, for working on a contingent fee basis, to have just one of these cases may not make a lot of financial sense, because when you view it through the prism of just a single case, maybe it's a $100,000 damage case and he's going to have to do all this work to earn his 1/3 contingent fee. It may not make financial sense for many high-level personal injury attorneys to take it. But once you got the first case and then that opened the door to all the future cases, obviously makes all the financial sense in the world to handle 25. But what's even weirder here is that in the Watson case, he was an attorney from Texas, practicing in Texas. Now he's going over and practicing in Nevada, where he's not, a local practicing attorney. So that represents a little bit of a quantum leap jurisdictionally, but you use local counsel and, it's all going to work out. But I think the leave with pay situation is very troubling to me, because if you read the language in the personal conduct policy, this fits all the parameters of being placed on the commissioner's exempt list. It's the first situation is when a player is formally charged with a crime of violence, meaning that he is accused of having used physical force or a weapon to injure or threaten another person. The formal charges may be in the form of an indictment by a grand jury, the filing of charges by a prosecutor, or an arraignment in a criminal court. In those cases where a crime of violence is suspected but further investigation is required, the commissioner may determine to place a player on the commissioner's exempt list. What is the NFL waiting for? You got a crime of violence, a felony battery, a criminal indictment. If this case doesn't merit the placing of the player on the commissioner's exempt list, then what action does? Murder? I mean, this is a felony battery. It should have been automatic from the very beginning. So I would expect at some point between now and the beginning of the season, unless these charges are miraculously dismissed before the start of the season, he's going to end up on that list. I don't see any way he doesn't.
I'm with you. It doesn't necessarily make sense to me what's happening, but here we are. While we're on the topic, Dan, you just kind of made you kind of saying in a jest, like what kind of acts would land you on the commissioner's exempt list, and you joke like murder. I guess it is what it is. We have a story this week that's a little kind of troubling, but it brings up some of those connotations. Aqib Talib, former cornerback with the NFL, really highly decorated player, a guy that's signed on, was tapped to be the in-studio analyst for the new Amazon NFL show. Is involved in a messy story. I watched the video on this and I regretted it the second I watched it. But long and short, Aqib Talib and his brother were at a youth football game. I think they were coaches or they were around the coaches, but there is an altercation that ensues and an argument that starts, I think, involving Aqib Talib and the coaches and the refs. And all of a sudden it starts to go physical. And you see someone holding the first down marker, kind of looking like they're using it as a weapon. And then all of a sudden you hear gunshots. And those gunshots were allegedly caused, and it was caused by Aqib Talib's brother pulling the trigger. He's now been charged with murder, and this person who now has succumbed to their injuries. And now Talib is stepping down from Amazon, even though he's not charged with murder, but he was involved in this altercation in some indirect way. Dan, I don't know. Is there some legal big takeaway from this?
Well, he's accused of instigating the brawl. And I mean, this tragedy has now impacted 3 lives. One man lost his life. Talib's brother was charged with murder, and Talib was accused of instigating the entire incident and starting the brawl, which actually led to the killing. So his career is over as a broadcaster. And from Amazon's perspective, the negative association attached with having someone on the broadcast team who is implicated in a murder is something that could never happen. And it's not just stepping away for the time being, unless there's an acquittal here. And, the tape obviously is very damaging to the brother, but there are many former players who would love to be part of an NFL, broadcast team broadcasting the games. There's absolutely no way he's ever going to be coming back. These are such few and far between coveted jobs, and what he's implicated in, there's no point of return from it. It's career ender in terms of being on a broadcast package announcing NFL games. This was the only decision that could have been reached. If he hadn't stepped away, Amazon would have taken action and removed him from the broadcast. There was absolutely no possible scenario with these charges hanging over the family and his brother that he could have continued in that role. So for purposes, it's a tragedy, but for his career as a broadcaster, it's over unless there's a complete misunderstanding of what happened. And there's a videotape that suggests otherwise. I haven't watched it, but I'll take your word for it.
Yeah, I don't think there's anything really else to add on this front. Obviously, it's a privilege, not a right, to work in the NFL. Same goes for being a studio analyst. Those jobs are paid a ton of money. And, that's why you got to be careful, what you do on and off the field. Dan, a topic we talked about maybe not last episode, a couple episodes ago, is Derek Jeter, right? The guy that surrounded himself with a really finite posse, a really small group, and he was never involved in any stories like that at all. So let's stick with that while we're here, right? We're talking about bad acts that you could be accused of off the field that could result in legal charges, right? That's what we're talking about with Deshaun Watson, with Tony Buzbee, Aqib Talib. Dan, this is a unique one. Nick Kyrgios, former Wimbledon finalist, a guy who is very entertaining to watch on the court, is being sued for something that he very much did on the court. So people that have not followed the story, I find it to be a very fascinating one. So Kyrgios wins the first set against Novak Djokovic. I had bet on Kyrgios in that event, so I was watching this one very closely, and for good reason, which we'll talk about. Kyrgios goes to the ump. He says that there's a fan in the crowd that's distracting him while he was serving. And he goes, and he told the ump that this woman was intoxicated and that she should be removed from the stands. That woman is removed from the stands. I have little kids, right? They're watching Princess Sophia. They're watching different shows. I have this thing on mute. I saw there was some commotion. I didn't really think that much about it. Dan, we now know all about this woman. She has now filed a defamation case and is claiming that Kyrgios' allegations were reckless and entirely baseless. And she's claiming reputational harm for what happened to her. And she says the whole world literally saw what was going on, and she feels that her reputation has been harmed. Dan, I have some thoughts on this, but I will let you take the lead on this one.
Well, it's not just that she was drunk. He used, I think, he made a hyperbolic statement that, this woman's had 700 drinks. Obviously, nobody's going to be taking that statement seriously because if you had 700 drinks, you would be dead. But I think the point is that his accusation or inference is that she was severely intoxicated. And I don't know if this is right, but I think I read somewhere that she's an attorney. Is that right? Well, she's not a public figure. And because she's not a public figure, and obviously this took place in another country, so the standards for defamation are going to be a little bit different. But not being a public figure, this could be problematic for the defendant in this case because the proof bar or the evidentiary threshold is going to be lower. I guess, for public figures in the United States, there's a higher threshold that you have to clear. But I think the implication is pretty clear that he accused her of being publicly intoxicated when in fact she wasn't, because she was allowed to return to a seat 15 minutes later. She had only had one drink and maybe she was acting inappropriately and trying to get his attention. But what she was not was intoxicated. And as an attorney, that's probably not the person you want to accuse of being drunk to the tune of 700 drinks.
So let's confirm some things. Yes, she is a lawyer. I'm not going to say
good.
You can look it up. She's 32. She is a lawyer, and as you pointed out, she was temporarily ejected. Now, Dan, here's the problem. Here's where I did tell you I had some thoughts on this, right? I don't know this woman's name. This woman's name, if you Google her, right? I'm not going to say it. People can figure it out. This is the only thing that comes up when you Google this woman's name. It's the only thing that comes up. I will say with 99% confidence, if you Googled this woman's name before the lawsuit, nothing would have come up. Probably her attorney profile page would have come up in whatever articles or literature that she had put out there, right? There is a concept, Dan, which I find to be a very fun one. It's called the Streisand effect. Dan, are you familiar with the Streisand effect? I can give you a little bit of background if you're not.
No, I'm not. I imagine this has something to do with Barbara Streisand or the attorney named Streisand in California.
No, that I do know him. I think he's involved with the Chargers lawsuit in some way, shape, or form. But yes, so this one is about the singer, Barbara Streisand. So it involves a lawsuit. Back in 2003, Barbara Streisand sued a photographer named Kenneth Adelman for posting a photo of her home online on his website, as a part of whatever his website collection. Okay. So interestingly, Dan, this is my favorite part. As part of this lawsuit, this guy, Kenneth Adelman, it wasn't a website that anybody really viewed. According to some reports that are out there, fewer than 10 people had ever seen that photograph of her home. It's this beautiful home on the coast, on the rocks. It's gorgeous. Only 10 people saw that photo. But when Barbara Streisand files the lawsuit, say, hey, how dare you take a picture of my house, right? Much more than 10 people ended up seeing that photo. So that concept in at least PR has been known as the Streisand effect. Filing a lawsuit and bringing yourself exponentially more attention to yourself. Maybe it's not good attention. So Barbara Streisand is really upset. All this harm from her house being posted online that literally 10 people saw it. And the same can apply to this 32-year-old lawyer who's now suing Nick Kyrgios. Now everyone knows Google knows who she is. Probably not a smart move if you're alleging reputational harm from what happened at Wimbledon months ago. And I have not heard of you. Dan, I think you had told me that you knew this woman's name. You're part of a very small few of people that remembered that incident. I didn't remember it.
Unlike the 10 people who saw Barbara Streisand's house, this incident went viral when it happened July 10th, a little bit more than a month ago. I mean, this is all over Twitter. I think I'm looking at Chris Hammer, was a Twitter account, 8,000 likes. It's a video of the incident. She's drunk out of her mind and talking to me in the middle of a game. She's the one who looks like she's had 700 drinks. There's a video of it. It was all over the internet.
Does it say her name, though? Does it say her name?
No, it doesn't.
It does not. That's the thing, right? In this day and age, we are only as valuable as our name recognition. So yes, I agree with you, right? Obviously more than 10 people were watching Wimbledon finals. I was watching it, and whatever. I couldn't have been 10% of the viewing audience, but this certainly does amplify those allegations. I'm sure she wasn't having 700 drinks. Dan, I posted a video on social media the other day of someone taking 50 shots and literally going to the hospital. If you've had 700 drinks, you're not going to the hospital. You're going to the morgue, right? So it's not possible. But at the end of the day, a defamation case, right, depends on someone giving a factual assertion, right? Did Nick Kyrgios actually mean that she had 700 drinks? No, he said she was acting inappropriate and was distracting him. So on its face, I don't even think the lawsuit has merit. I think it was just a a waste of time and not a lawsuit that my firm would have accepted. I don't think many
I
firms.
don't know about that. I mean, if it was only the 700 drinks comment, I would agree with you. But I think he said she was drunk out of her mind as well. And this was amplified and broadcast the world over, and he meant it and held her up to, some amount of ridicule because she was sitting in one of the front rows. She was visible. I think there were photos or videos of her taken. So certainly her identity could be ascertained. Is this a multi-million-dollar case? I don't think so, but I think her suit could have merit. And this is probably designed to elicit an apology and some nice monetary settlement. What that amount is, I'll leave it to those two sides to figure out, but I don't think this is ever going to go to trial. I don't know what kind of defense he would be able to maintain, that I was just kidding. I don't know. It didn't sound like he was kidding.
Listen, we don't have to get into so much in the weeds here, but I'm curious, right? How about the other side of it? Nick Kyrgios, if he said it, he might have meant it, right? I think he was probably giving some form of an opinion. I don't know if he was actually stating fact, but then how was she going to defend it, right? Did she take some type of breathalyzer test at Wimbledon, right? How did they discern that she wasn't actually drunk? Maybe she paid a lot of money for those seats, and you are allowed to have alcoholic beverages at events, right? They serve them there for a reason. So maybe there's something in the middle here, right? Maybe she wasn't necessarily stone cold sober, but she obviously didn't have 700 drinks. And then, right, that's why on this case, right, she's not a public figure, right? We can go into the whole actual malice standard. I don't know where the truth lies. And it just seems like if I was advising her, right, let's say I wasn't a lawyer and I wasn't analyzing whether this case will win or not, which is a separate conversation. If I was her friend, I would never tell her to file this lawsuit. I think that was unless, Dan, if I'm wrong and she gets like a $5 million payday or something crazy, then I'm happy to say I'm wrong. But from a reputational perspective, you cannot delete what's on Google. And now for the history of mankind, right, on Google, she will be known as the woman that got thrown out of Wimbledon. But
she's going to have to, make a cost benefit analysis. How much does she make being a Polish medical lawyer? Because that's how she's described on the internet, versus the potential upside benefit of getting a $500,000 and up payday in a settlement. So it may be worth it for her, because I believe people who know her saw this on television and know that was her. I think this is a real easy, quick strike settlement for her. And I doubt that we're going to be hearing about this case ever going to trial.
Okay, so let's put the pin on that one, and I agree. I don't think it's a case that goes very far either from settlement or some other type of dispositive motion practice. But Dan, you mentioned the Nick Kyrgios case is likely not one that's going to be going to trial. I will agree with you there. A case that is very much in the midst of a very high-profile trial is the Vanessa Bryant case. For those that don't know, Vanessa Bryant, the widow of Kobe Bryant, initially filed a lawsuit for wrongful death based on the helicopter crash. This is a lawsuit pertaining to the tort of invasion of privacy. Vanessa Bryant and another plaintiff, Chris Chester, who is a surviving family member of one of the other decedents of the crash, is alleging that photographs from the crash site were taken by law enforcement members and unlawfully disseminated. The tort is for invasion of privacy. Again, we could talk about the liability, we could talk about the damages phase, but it's a trial that's wrapping up soon. So we wanted to give a little bit of a preview, and then we'll probably bring someone to talk about the result whenever we have one. But Dan, I will kick it to you.
Yeah, I mean, there are going to be two very important legal issues here. I mean, the trial is wrapping up. We could get a verdict within the next couple of days, and we'll bring on, sort of one of the attendees at the trial to really dive into what their perception of the case was like. But this is a very difficult theory of liability. This isn't just a straightforward invasion of privacy state law tort. The primary claim in this lawsuit is a theory of municipal liability under Section 1983, 42 USC Section 1983, which is a way to bring private causes of action against state actors for violating constitutional rights. And here, the constitutional violation is a 14th Amendment substantive due process claim based on a standard of shocking the conscience. I think we could all sort of reasonably understand that displaying photos of dead people following a tragic accident would shock the conscience if materials like this were ever entering the public domain. But this is a very difficult claim. I think there are going to be issues on appeal, even if there's a verdict in favor of Vanessa Bryant, because there's only one case that has ever recognized a constitutional right to prevent the public dissemination of the photos of loved ones. And it's a case called Marsh versus the County of San Diego. And the plaintiffs, Vanessa Bryant, is hanging her case on that one judicial decision. But in that case, there were autopsy photos that were sent to the press, and family members could easily come across it on the internet. Here, the dissemination of the crash site photos was not as widely disseminated. I think based upon the allegations in the complaint and the evidence, there was one sheriff's deputy who showed the photos to a bartender, and then there was a LA County Fire Department employee who showed the photos on his cell phone to a group of other firefighters at an awards banquet. There's been no allegation that there's been any widespread dissemination. It's not on the internet. The photos were deleted. And the theory here, at least the allegation made by Vanessa Bryant, is that she's worried about what could happen and that she's panicked and fearful over the eventual prospect of public release of these photos, when in reality, at least at this stage in time, at this point in time, the release or the dissemination of the photos has been much narrower as compared to the Marsh case, where the autopsy photos were sent to a newspaper and were available and could be viewed by any family member through any number of channels. So I think this case presents not the same situation on all fours as the Marsh case. So I think it's going to be difficult, at least from an appellate perspective, to make this judgment stand if Vanessa Bryant wins the case. I know the judge denied a motion for summary judgment, but that doesn't foreclose the possibility of an appeal to the Ninth Circuit U.S. Court of Appeals. And I think that's where the case could be headed. What do you think about that aspect of it before we turn to damages?
I guess we can talk about liability while we're here. There is an allegation from Vanessa Bryant's camp and Chris Chester's camp that the photographs, the actual photographs in question, were improperly deleted. So it's a concept we have not talked about on the podcast in some time, but it's the concept of spoliation, that you're not allowed to intentionally delete evidence that's potentially at the center of a case, where the prospect of litigation has started, or you could potentially know that there could be litigation. So, the LA County Sheriff's Department is admitting that they deleted the photographs, and they essentially offered amnesty to any law enforcement members that came forward, admitted they had the photographs, and they would not have faced any disciplinary measures with respect to, I think, with the exception of maybe some type of small note in their file, but they wouldn't be terminated or anything like that. So, the photographs are deleted, sure. But in this day and age with e-discovery and whatnot, you could probably get a sense of where those photos are transmitted. You could find, actually how many people have the photographs, right? That small number is what we know, people that have admitted to it. But in this day and age, right, it's very hard to keep a photo, any type of photo with some I don't know, news value. I don't even know if this has any news value, but a photo like that under wraps. So you're basically taking the LA Sheriff's Department's word for it, that a photo has not gone beyond this amount of people. And coincidentally, it's a very small universe of people, which I don't think we know about. To your point, Dan, on the actual legalese, right? Vanessa Bryant is thinking that she's going to be harmed in the future, but you can't really necessarily compensate someone for something that hasn't happened yet.
You're absolutely right.
But if we're trying to figure out this bridging of the gap of spoliation, right? Part of the reason we don't know how many people have the photo is because of an affirmative act that the LA County Sheriff's Department did. So I haven't seen if there's been a ruling on the spoliation charge of the case. I know that was a conversation early on, but I think Vanessa Bryant is right. Like, hey, A, these people should have been punished. Number one, why did you give them amnesty? And number two, that's not the legal part, but number two, that might have impacted her ability to move forward with the case.
Yeah, I think what was interesting, some of the testimony that came out from an expert was that it's a common practice for law enforcement personnel to keep so-called death books, where they, keep photos and, as almost like trophy photos to share among themselves in small groups, that they actually keep this kind of evidence. And while the LA County Sheriff's Office may not have been presented with a prior complaint about that, which could be a critical fact, I think the former LA County Sheriff said there was common practice, unfortunately, for law enforcement personnel to do this kind of thing. Yet, does it rise to the level of a municipal policy, practice, or custom? And that's the threshold. There's not automatic vicarious liability here, that if the sheriff's deputy, if Joey Cruz, who's the LA County Sheriff, trainee or deputy who showed the photo to the bartender, or if Tommy or
That's
Tony
right.
and Greta, the LA County Fire Department official, showed the photos to other firefighters at a gala event, there's not an automatic imputation of liability under a vicarious liability theory under Section 1983. You have to show it was a de facto policy, practice, or custom. And what militates against that here is that this was the first instance in which a matter like this has ever been brought to the attention of the Sheriff's Department. There's no prior precedent which would have given the LA County Sheriff's Department notice that this type of thing was recurring and frequent, and this is something that they should have been training their employees on how to handle human remains and how to, sort of document and what not to do. So this is going to present a very interesting legal issue, I think, on appeal, unless there's a settlement in the case. So I think just previewing a possible issue going forward is whether Vanessa Bryant is going to be able to meet the high bar for municipal liability under the Monell case for Section 1983 claims. That's a very difficult theory of liability to establish. I've been involved in cases like that in the past, and they're very tough to prove. And I'm surprised that one got past a motion for summary judgment, but it's not the end of the game. We could have Ninth Circuit review on that point.
Let's talk about damages here, and then we don't have to go further on it. But I mean, there was a story I remember, we covered it briefly on the show. LA County approves $2.5 million settlement with two families over the alleged unlawful release of the crash scene photos. So that gives you an idea of what the settlement numbers we're talking about here, right? LA County's attorneys are looking at a number around like 1 to 2 million, which is not a small number by any means, but that's not, I think the number that Vanessa Bryant has in her head. So that number was taken, and Vanessa Bryant and Chris Chester, another plaintiff in the case, they want much more than that. So how much more is much more? Dan, between the two plaintiffs, the number is $75 million. So that's what we call being way off in terms of numbers. So Dan, I don't know how to put a value on it. And you never know with juries in the sense, how much the constant fear of the photos being released is worth. There was a comment, I was reading, I'll give a shout out to courthousenews.com, had some coverage of the case that I used for my research on this. But according to the judge, at least according to the report, the judge had urged the parties to settle because the judge didn't think that Vanessa would, and the remaining plaintiffs, Chris Chester, would be getting anywhere close to what they were looking for. So yeah, that number is now reported. Brent Schoenberger, he's a friend of the show, see if we can get him on, in the coming days and weeks. But he's alleging $42.5 million is sought by Vanessa Bryant, and $32.5 million is sought for plaintiff Chris Chester. So $75 million in damages. Dan, that is a long ways off from $2.5 million for two plaintiffs.
And it's also a long ways off from reality. I mean, there are most wrongful death cases, medical malpractice, somebody dying. You don't get judgments of $40 or $75 million. Vanessa Bryant is worth $600 million. The photos were shown to probably a universe of less than 50 people. There's been no widespread dissemination. There's just the constant, ever-present fear that someday this could turn up on the internet, and maybe she's got a point about that. But if you look at the scale of damages for real, death situations where I can't think of an invasion of privacy case. Maybe Hulk Hogan was one like that actually, caused real career harm to him. But if wrongful death cases themselves aren't going to be generating these types of monetary recoveries, I think an invasion of privacy claim based upon the release of death scene photos, I think the scale we're talking about is probably in the mid 7 to low 8 figures and coming nowhere near a 75. Now it's not 75 million per plaintiff. I think it's 40 million for Bryant, 30 million for her co-plaintiff, who's not a public figure. But I think that kind of money is absolutely off the rails in terms of bearing any, reasonableness to the underlying offense. I don't think it's a $40 million case. I think it's a $10 million case at most. And if it would have been a $10 million case from Vanessa Bryant's perspective, this case never would have gone to trial. She's looking for a huge score here because she thinks she can get it. And there's a fairly decent chance Los Angeles County jury will be swayed by emotion and can award an amount like that. The question is it worth it? Will it stand up on appeal? And I don't think a $40 million damage award, given the limited distribution, makes any sense. It's so out of disproportion to the extent of the dissemination that I think we're looking at something much lower than that. So we've got potential issues on liability, as well as potential legal challenges or appellate review issues on the reasonableness of the damages.
I'm with you, Dan. You alluded to a point that we spent a lot of time on last year. At the end of the day, right, this jury is in California, where Kobe Bryant once upon a time made his name. So, do you want to be on the jury that threw out Vanessa Bryant's case? Probably not. But, that's what voir dire is for. That's what jury selection is for, to try to weed out those people that potentially would be biased. But
federal court jury and state courts are much more notorious than federal courts in giving significant outsized plaintiffs awards. In federal court, the judges are much more hands-on and proactive in instructing the jury on the proper measure of damages. And while state court judges can certainly do the same thing, I believe a federal judge will be much more engaged and involved in paring down an unreasonable damage award post-judgment. So there are going to be many hurdles here. You've got to, the judge is going to instruct the jury. There's going to be post-trial motion practice, a remittitor to reduce the amount of damages, and then the prospect of taking an appeal to the Ninth Circuit U.S. Court of Appeals. So I think where this should end up, again, I'm not listening to the evidence, but this seems like a high 7 figures, low 8 figures damage award at best. And if it gets much higher than that, we're talking about serious appellate issues.
We will keep an eye on it. And again, we'll cover whenever the verdict comes in. Hopefully we get, we get that pretty soon so we can cover it for you guys. Okay. Sticking within the world of basketball, another story we haven't covered that frequently on the show, but another kind of decision point in the process. Brittney Griner, WNBA player, has been trapped, in Russia, accused of certain crimes involving cannabis oil. We don't have to get into that, but we have now moved to the phase, right? Brittney Griner was sentenced to 9 years in prison, kind of a protracted trial, but we are here to the phase of, is she going to be brought back to America? What is going to happen? Is there some type of trade negotiation going on with the government? So in the middle of all of this, of all people, Dennis Rodman, former Chicago Bull great, pops up and he says that he is going to be heading to Russia to try to use his contacts with Putin to bring her home. So it set up a whirlwind on social media, and then the Biden administration felt the need to respond and essentially said, quote, this is the Biden administration, Ned Price, a State Department spokesperson. He says, quote, we believe that anything other than negotiating further through the established channel is likely to complicate and hinder those release efforts. And then very quickly, maybe the news that not everybody saw, Dennis Rodman himself decides to reverse course and says that he is not going to be heading over there. So Dan, we got to address the news as it comes to us. I think probably Dennis Rodman has a right? He would probably be more hurtful than helpful, I would think.
Well, if this were North Korea, Dan, where he has a little bit of an established relationship with the leader of that country and a track record of getting prisoners released, I would say go for it. But I think Russia's going to be a little bit of a steeper climb, and Dennis Rodman wisely backed off because I don't think he has the same level of influence within the Russian government that he had within the North Korean government. And it was nothing more than a publicity stunt for Mr. Rodman. And clearly enough people told him to let the formal back channel communications proceed as they are, because I think both sides were amenable to having some type of substantive discussion on an exchange of prisoners. So why interfere with that? And he could be charged with a crime. So there's very little upside here for Dennis Rodman other than a publicity stunt. But if I felt that he could be helpful to her cause, I would say, why not? But this isn't the same type of situation that he was involved in years ago when he went to North Korea and Kenneth Bay was freed. So I think he wisely stepped aside. I don't think it's much of a story. It's just another in a long line of Dennis Rodman surfacing for the need to have publicity.
I was going to say, I was not aware that Dennis Rodman actually had a track record. Is that confirmed by the State Department that he has a track record of bringing people home, or is that in Dennis Rodman's Twitter account?
I don't think there's a page showing the statistics, but he did travel to North Korea. I forget the year, but the political prisoner or the prisoner there was Kenneth Bay. And I think this dates back to 2014. And Kenneth Bay thanked Dennis Rodman for being the catalyst for his release. So Rodman did have played some role in expediting Kenneth Bay's release from North Korea. But Russia, it's definitely a much more challenging climb, and not quite the same thing as North Korea, where the leader of the country is a big basketball fan and just relished having a celebrity like Dennis Rodman in his country. I don't think Vladimir Putin is going to feel quite the same way, or have nearly the same kind of enthusiasm for Dennis Rodman's presence. It's a lot more complicated than that. And these discussions are taking place. And the only thing Rodman could do is derail these things by calling undue attention to the issue when the two countries are quietly negotiating behind the scenes.
I think we can end that there. And Dan, we'll give it to you. Dan, I always perk up when you start talking about Florida sports betting. New York has since had Florida sports betting come to the scene. California, we're still working on. Florida briefly legalized. We can get into the Calvin Ridley saga. Well, he was maybe a footnote to that when Florida briefly legalized with the Hard Rock. But Dan, as I'm told, there is another battle that is percolating over in the Florida sports betting universe. So I'll hand it to you to break it down.
Yeah, when we last left this saga back in November of 2021, a District of Columbia federal court issued a decision invalidating a tribal gaming compact, which was an agreement between the state of Florida and the Seminole Tribe of Florida, but to basically give the Seminoles a monopoly over statewide sports betting, both retail on Indian lands, as well as the right to have statewide mobile. And the entire compact was predicated on this notion of the server being located on Indian lands, because under this federal law known as the Indian Gaming Regulatory Act, all the gaming has to take place on Indian lands. And with mobile betting, the customers are located outside of Indian territory. So the Seminoles and the state came up with a sort of a concept of determining that the entire bet takes place on Indian territory because that's where the server is located. And the DC federal court struck that down, characterizing that as a fiction that is not supported by the language of the statute or by the case law. So 9 months later, we finally are in the first round of the appellate briefs. The Seminole Tribe and the Department of the Interior filed appeals last November. And today, or at least last week, the first briefs were filed in the case. The opening brief in front of the DC Circuit Court of Appeals, the Seminole Tribe are arguing that the compact is not even reviewable by a federal court because the tribe is protected by sovereign immunity. So they're not even defending the merits of the compact. They're arguing that the tribe should have been named as a necessary and indispensable party to the lawsuit, and their exclusion from the lawsuit warrants a dismissal from the case because even had they been added, they would be protected by sovereign immunity. So they're not out arguing the merits, they're arguing sovereign immunity. At the same time, the United States Department of Justice filed an opening brief on behalf of the Department of the Interior, which is the agency that approved the compact. And the Department of the Interior is now arguing that the compact never authorized online sports betting. They're deviating from the Seminole Tribe's theory. The Seminole Tribe was always arguing that compacts can include and authorize online sports betting because it's based upon the server location, not the location of the customer. Now the Department of Justice is arguing, we don't believe that the location of the customer even matters at all. This is something that state law has authorized, not the compact. And all the compact does is allocate jurisdiction from Florida state authorities to tribal authorities to determine and regulate how betting outside of Indian land is to take place. It's a very convoluted argument that probably requires a full episode to explain. But the federal government is now taking the position that their view of the compact is that it only authorizes in-person sports betting, which is perfectly permissible under federal law, and it's state law that authorizes the stuff that everybody's complaining about, which is online sports betting, and issues of state law don't get analyzed by the Department of the Interior. The Department of the Interior only reviews a compact for compliance with federal law. So that's the basis of the Department of Justice's argument. They've shifted gears and recalibrated the legal argument in this case to focus on this hybrid approach where the compact authorizes in-person betting and state law authorizes online betting, and state law is beyond the purview of what the Department of the Interior can consider. So where is this all headed, Dan? This is round one. The plaintiffs in the case, West Flagler, are going to file their response brief, their answer brief in mid-October. A reply brief will be due in November. This case is headed to oral argument, and I would expect oral argument to take place later this year, early 2023. We're not going to get a decision until probably the springtime of 2023. Then it will likely be the non-prevailing party will seek rehearing en banc before the full DC circuit. And the non-prevailing party after that could seek US Supreme Court review. So from a timing perspective, I don't see a resolution of this controversy until 2024 at least, which means that the earliest you're going to be able to place an online sports bet when you visit your in-laws in Florida will probably be 2024. And it's not going to happen through this lawsuit. It will probably happen through a ballot initiative where the voters decide the question.
Dan, we'll obviously keep tabs with you on that case. We are recording this on Wednesday. The college season starts on Saturday. with Nebraska and Northwestern kicking off the season. And we are very, very close to the start of the NFL season. So obviously stay tuned to us, all things sports and law, gave you anything and everything across the sports law world. So we always enjoy doing it every week for you guys. So this episode, it goes without saying, this episode is sponsored by Themis Bar Review, the top bar prep company in the galaxy. Dan, I'm told we might have some additional sponsors in the show. Just put it out there. Just to put it out there. But Themis is always number one with us. Top bar prep company in the entire galaxy. We've been great friends with Themis since this partnership started. So it's nice to see some other sponsors percolating. At some point, Dan, you and I will get our act together and we'll get on our pony and help grow the show some. But for now, we're all about providing good content. Dan, anything else to add before we officially put this episode in the books and I run to my call that I'm about to be late for?
Yeah, absolutely. We'll pick it up back again next week. We're getting closer to the NFL season. We're going to have some special shows and guests coming up in the approaching weeks. So I think this was a pretty good episode covering a lot of different topics, moving on from the Deshaun Watson saga. So we got some new issues to cover this week and going forward as well.
All good. For Dan Wallach, myself, the Conduct Detrimental family, we will see you all next time on another episode of Conduct Detrimental.